Hi, everybody. Dear Chairman, dear staff members and working committees and fellow speakers, thank you for having me today. So now, let me just share my screen. So please let me know if everybody can see my screen here.
I can see your screen, Harry.
Okay, and the full screen. Excellent. So thank you very much for having me today on this important topic. And much has been spoken in the market about climate change as an emerging risk and the importance for the industry to stay on top of that. Today, I'm very happy to join the message reinforcement for the common interest of the industry. And I'm trying to do that by doing three things. So first of all, I would focus more specifically on climate change litigation and its potential impact on liability classes of business. And then secondly, I try to make the picture more tangible for you by navigating the trends, a number of law scenarios we typically see in the road space, and also some real examples from other regions, including ANZ. And then lastly, I'm also open and now look to try to share a little bit on the policy wording side, what we are seeing in terms of the existing challenges and what we may predict in terms of the evolvement in future about policy wording and coverage. So with that, I'd just like to bring here the first picture in terms of numbers. So according to the Sabin Center of Law at the Columbia University, during the course of the past 15 years, we have been seeing filing of CCL cases trending up. More particularly, for each year in the past 5 years, not less than 150 filings have been made everywhere in the world. And if you look at the number last year in February, it stood at 1,890, but now it has jumped to 2,344 nowadays. To have an easy understanding the concept of climate change litigation, I have conceptualized here the global scenario into 5 pieces. In the first box, it's about administration action brought by environmental groups against the governments. And these occupy the majority of the filings globally. For the government's failure to enforce climate change regulations or to drive meaningful targets. In the second bubble, it's about the group of civil claims related to climate change contribution against corporations. Here, the plaintiffs are seeking either monetary compensation for their loss in property or bodily injury, or seeking court orders or relief. For example, to stop an oil production company from emitting carbon dioxide up to a certain level. In the third group of cases around disclosure liabilities, and they can either be civil or regulatory by nature, regarding corporate climate-related financial risks on the business investments or operations. On the flip side of disclosure, misleading statements made by executives or companies. In the fourth box, regarding their products, investments, or actions. And when the plaintiff rely on these statements, they suffer a loss and they will sue against the company executives or the entity themselves. In the last box, we can collectively group breach of executives or professional service providers' duty in terms of risk management of the climate-related risk. So one example which has happened actually in the US is about the investors' suit against the board of directors for their failure to work out the transition plan related to climate change. In case you're still scratching your head as to what CCL actually means, here I like to offer 4 examples, which are real cases from all regions of the world. In the first case is the US tortious action regarding direct contribution to climate change and its consequences. And it's about the US Fishermen's Association's claim against the oil producers wrong for its attribution to ocean warming, causing destruction of the seafood farms they owned. And allegedly, is upon the allegation that they are burning fossil fuels, which is a product known of adverse consequences. This case was started in late 2018, and it is still pending in the US court. The second case comes from Holland and is a landmark case of significant importance. It's about an EU human rights class action against, again, the energy producer Shell. There, the Hague District Court ordered Shell and its subsidiaries to reduce their emissions of carbon dioxide by 45% by 2030 in comparison to the 2019 level. And it's the first occasion in which a national court would order a private company on a lawful duty to reduce both direct and indirect carbon dioxide emissions. And that also extends to the duty to influence the end product users to reduce their emissions. Swinging to the third box is a case of a very different nature. Is in the US, the investors claim against an energy company for their failure to implement climate-related transition plan. In that case, it was found that because of the outdated equipment of the utility company, it contributed to the outbreak of the wildfires in California. And as a result, a huge settlement of damages to the victims were made, leading to the insolvency of the company. And the investors sued the directors for their breach of duty, and the resulted financial loss. In the last column on the right-hand side is a very fresh case from Australia, which was announced just in late February. And there, the Australian Securities and Investment Commission has announced its first greenwashing proceedings against a corporate pension fund. And it's for the false and misleading green credential they have made in their website, whereas in fact, the fund was investing in coal and other fossil fuel, and also along with alcohol and gambling stocks. We are not sure whether this case may also trigger claims from investor, and we will be keeping a close eye on this case. So here, I would like to give a high-level summary on the current legal landscape of CCL globally. So starting from the first box, as we are seeing growing environmental impacts, which may open up new litigation pathways. So for example, it's very evident that we are seeing a variety of courses of action, ranging from talks to consumer and investor protections, to corporate disclosure duty, and also extending to human rights. And that indicates a diverse class of parties, either from the private sector, from the financial sector, or even against the government, of nature either can be civil, regulatory, or administrative. And secondly, we are also observing that the judicial attitudes potentially are also evolving. Of the vast amount of filing, which is still pending, we are not seeing ready dismissal of the cases by the court or judges, or deferring of them to the legislature or governments. And in fact, as we have seen from the Dutch case, sometimes the judges are very willing to create new duty at all. And then thirdly, in the consumer protection, corporate disclosure, and directors' duty space, we are also seeing heightening regulatory interest. And this will be converted into new regulation and requirements. And with the new requirements and standards, it's also a good breeding ground for future violation investigation and legal disputes. The new UK regime for financial disclosure related to climate change, which was just implemented last year in April, can be a very good potential of litigation, which requires, for example, private companies of a size more than 500 employees or a turnover of 5 million UK pounds to declare in their annual report their strategy related to handling climate change risks. And don't forget, in the fourth box, apart from consumer and investor protection, we also have human rights in the equation, which is being used as a weapon to compel governments or private companies to do more. And the impact of this should not be underestimated. The reason is for the major human rights regimes, more particularly with the common law and Commonwealth countries, the requirements are quite homogeneous. As a result, there is a high degree of transferability of this human rights impact across the major and leading jurisdictions, leading to further developments in the law and the regimes. And then finally, especially in EMEA, we are seeing claims based in civil law, which may also provide additional source for liability, because there the plaintiffs are quite willing to test the water and by creating very creative and new legal arguments. And all these elements are also reinforcing each other. There is a lot in the tank to fuel the development in the legal space. On this slide, I also want to highlight a little bit in terms of the industrial segment, which sectors are more exposed or being fund targets of CCL. So no surprise about the energy sector when it comes to oil, gas, and coal. They are being the carbon majors, account for 90% of targets. You may ask about the reason why food and agriculture is on the list. This is because food and agriculture also involve emission of greenhouse gases. And then on the other hand, in this industry, there is very low level of investment for climate change related policy. Plastic industry is also on the target due to the very nature of plastic products has a strong origination with fossil fuel, and also during their entire life cycle, starting from production, conversion, and then to the end of life treatments would also involve emission of greenhouse gases. And then for transportation, for production of alternative energy like electricity, and some manufacturing and industrial sector, they have the reliance on fossil fuel and their outdated equipment and machinery related to traditional combustion would also put that as targets by environmental groups. So here is a summary and matching of the 5 litigation scenarios I just outlined to the traditional liability lines of business. So firstly, when it comes to claims related to property damage or bodily injury, it's quite obviously that if they are due to climate change, contribution, or impact, it can potentially fit with the commercial general liability policy. And on the same basis, if the allegation is more specifically related to the insured product, in terms of misleading product disclosure or failure of the product's performance to live up to the current climate situation, it may also produce potential claims related to product liability policy. And for those who are quicker in following the rail, you probably have observed that D&O class of business is very prone to CCL exposure, for the very reason that the nature of D&O product is to indemnify and defend for the directors and executives for their breach of duty. And if there is anything related to failure to prepare for climate change, misstatements, and also on compliance with certain regulations, that will expose the policyholders to those potential claims and litigations. And don't forget about the entity investigation expenses cover, which is not litigation, but it can also involve a huge amount of legal fees in preparing for regulators' investigation in a particular company when it comes to climate change disclosure or other potential violations. And then, in the same token, in general, professional breach of duty may also expose the policyholders to claims related to climate change. So in the last part, this is not a wording deep dive, but I just want to lay off an outlook when we look at the existing technical complication related to policy coverage. How we may predict possible involvements in the coverage or market policy wording going forward. And at this juncture, I also like to chip in a very important message related to the exposure on defense costs. There is a lot of the climate change litigation cases are pending, and with a relatively low amount of them actually have found established liability. Don't forget, the very nature of the liability policy is to defend for the policyholders. And it is still a very significant exposure potentially to insurer when it comes to defense costs. So on this, the first big question is in relation to policy figures. And when it comes to especially commercial general liability, a big question to ask by people is whether a climate change-based event can be considered as an occurrence. So there is a question around what and when is the occurrence of events. How about if it's per emission? Would that be the case? Or somebody can argue that and continuing emissions can be considered as one emission. And as a result, how can we aggregate the events or a series of events? If that looks a little far-fetching for you, how about if the claimants change a little bit their claim by giving a quantitative trigger to the occurrence? For example, when there is allegation that certain emissions exceed a regulatory level. The final question on this aspect is also to consider whether the occurrence, the conduct is accidental or is something expected or intended because they have been allowed to carry on. For example, in terms of the carbon dioxide emission for a number of years, it can be also considered as intended. So much would depend on the particular case and the allegation and also the particular policy wording. The other technical focus, which actually has brewed into some responses in the market, is to consider the effectiveness of existing traditional pollution exclusions. So there were 3 levels around this. And the first layer broadly is what would also be opposed by the courts, is whether the judicially understood purpose and intent of those exclusion are they fit for the prolonged and known emission. On the second level is about exercising those exclusion to the particular case, and that involves the issue of causation by looking at the degree of connection between the pollution policy defects and the particular impacts complained about. So, for example, can one attribute a climate-related illness to a particular emission or carbon dioxide pollution? The third aspect is to look at whether pollutants are defined in a particular policy and whether the greenhouse gases or carbon dioxide emissions can be considered as pollutants. As I have mentioned, the consideration on the effectiveness of traditional pollution exclusion has brought up some market responses. So here we are seeing, particularly in the US market, in the general commercial liability space, we are seeing exclusions related to climate change harm. So the first bigger one is for the LMA 5570, which is drafted extensively and broadly in terms of language, and just broadly based on the insurer's contribution to climate change. In the US market, we have seen such climate harm exclusion defined in a more meticulous manner by giving climate change a particular definition, well, these others are defined in terms of global warming, and some is defined in terms of the effect of greenhouse gases. On the D&O space, we also have seen some bespoke coverage related to environmental mismanagement. And we have seen samples in which environmental events can be defined to include greenhouse gases. Given the current market conditions and the heightened concern about climate change litigation, I'm not sure if the market players would still offer this kind of extension. But that's probably something that would be demanded by the market or different by the brokers. For example, a major insurance broker just stated the best practice is to calling for enhancing existing D&O insurance to expressly include potential environmental. And then on the other hand, in the UK market, we are also seeing samples endorsement related to entity climate change investigation expenses, which is limited to a particular threshold. So I would like to wrap up my sharing in some key messages for the industry. So firstly, I hope everybody can perceive climate change as both a multiplier of existing duty and also a new source of duty. Having seen the variety of CCL cases from all over the world. And then secondly, also to emphasize that climate change litigation is more prone to financial lines, which is also a conclusion already drawn by the Bank of England. Thirdly, as I have mentioned, duty to defend is more easily triggered than duty to indemnify. So that's something we need to watch out in terms of defense cost exposure. And fourthly, also based on the legal landscape, there is a strong past nature of climate change litigations. And even though something arises out of the same one threat, it may implicate multiple plaintiffs, either from the civil or public side, and it can also potentially implicate multiple defendants. And when it comes to a wrongful act which is cost-based, it also has technically a higher potential of application. And then finally, we also need to watch on the developments and market demand, which will be driving involvement in policy wording or coverage conditions. So with that, I'd like to close my sharing and go to the Q&A session. So let me hand over back to you, Andreas.
Thank you, Harry. Thank you for this fascinating insight. It's really fascinating how climate change is affecting every aspect of our business. Thank you for updating us on the legal landscape. And to the audience, there's a button below somewhere here where you can submit your questions. Please do so. Make use of this opportunity to ask an expert questions on the legal aspects of climate change. Let's wait a few seconds until the questions are coming in. In the meantime, Harry, from your day-to-day experience, I guess you're working closely with the Chief Underwriting Officer within your organization. Which lines of business are in higher need of having to change their clauses? Or has that happened already?
Yeah, so right now, from our function, we are working closely with the underwriting office and the center, for example, to analyze on a portfolio basis what would the potential exposure related to climate change, either express or silence. So that's probably also coming from the liability line of business. And we are also observing in the markets what are the new wordings, either in terms of exclusions or extensions, which have emerged in the markets, and what would the impacts if they're implemented on our contract portfolio. And we are also responsible for giving advice to underwriters in terms of what they want to exclude or what they may consider to understand about the meaning of those clauses. Because it is only through understanding what is the concept of scope applications when they are converted into the language on our agreements, we can have a complete underwriting view in terms of pricing and provision of coverage.
Thank you. Again, to the audience, do submit your questions. Make use of this opportunity to ask Harry. Yeah, one question has come in. Let me read it for you.
Yes.
typically, actuaries look at the past to predict the future. How do you convince underwriters that the pricing would need to account for future risks like ESG, which will occur 4 to 5 years down the line, which have not been experienced before? I personally found, this must be a pricing actuary. I personally found a lot of resistance being targeted as conservative.
Yeah, I think the first thing we need to do as an industry, and that's something I also encourage the cross-functional team from claims, from underwriting, and from client managers to really stay on top of what's evolving on the legal and market landscape. Because we need to be forward-looking, and we also need the knowledge to form a really concrete view in the way we are seeing exposures. So those real examples and cases which have already available in the market is really worth our studying. There is also happening, for example, from the claims function, from the daily interaction with the markets, about what's happening in the back end. So I would strongly encourage the cross-functional team to work together. And the other thing we need to do is to be able to grasp a lot of examples, because it's only through the example we can know more confidently about the loss scenarios. And in a way, we can also be able to explain what it means to our clients, which is our first line of defense. And the ability to explain what it means by tangible examples to your clients will be critical in driving the risk perception in the industry.
Thank you, Harry. So pricing actuaries in the audience, now you know what to do. Now you know how to convince your colleagues from underwriting. Harry, now that you've given advice to the pricing actuaries, can you also give some advice to the reserving actuaries in the audience? Will they have to, or if they feel the need to adjust the reserves for the same reasons, what should they do to get buy-in from their colleagues?
Yeah, I think again, in terms of reserving, yeah, I believe every company or institution have their own reserving policy. But I think to be able to draw on experience from the claims function and the underwriting function to predict more about the loss scenario, as I said, would be critical. On the other hand, it is not just a tomorrow question, because we need to be more forward-looking in the next number of years. I think starting to build up the data points related to coverage, related to wording, related to possible claim cases of a loss scenario will also be very important. Because right now, even in the largest corporations or the clients that we have worked with, having really good structured data is not something we have been proactively invested into. Still, on a daily basis, a lot of reliance is still on relying on the existing tools and systems, which has been used for more than 10 years. So I think another good advice for me is to start to think about the data points and how to improve the structuring of data.
Thank you, Harry. Any other questions from the audience? We shall wait a few more seconds. Don't be shy.
Also try to think more laterally and not just specifically on a particular concept. So nowadays, it may not just be a specific issue on climate change, but we are also seeing, for example, other legal means in which plaintiffs can advance their cases. So class action For example, is something we need to watch on naturally, not specifically related to climate change, but it can also be a multiplier of the impact of a particular exposure when the commercialized class action can be a more ready tool to encourage litigation.
Thank you.